the petitioner ready to proceed then?
Yes, Your Honor. Thank you for the time. I appreciate it.
No problem. Go ahead.
This is my closing statement. Testimony and witnesses have already presented to the court and show that while I have been under a great deal of stress since October, and I do not deny that, I have sought professional assistance to manage it in a mature and responsible fashion. During the entire duration since October, the children have remained healthy while in my care, and I've ensured them getting to school on time as well as getting the services they need to help manage the stress of the time that they were separated from me in October. Most importantly, I have continued to be a loving mother, caring for my sons, giving them a pleasant holiday experience and pleasant birthdays. I tell my children every night that they are safe and loved. I continue to speak well of the respondent while she has disparaged me to the children by informing them of the criminal incident and details of that incident, which she denied under oath, but was directly referred to with the allowed testimony of Christy Imus. There is no meaningful evidence presented today that shows the respondent's allegations are true, as her allegations have simply been addressed with witnesses, 2 of them that have been abusers of me. The court already ruled that the DV incident in October would not be a limiting factor to my parenting time, and that was ruled on October 14th, 2019 by Commissioner Scheinberg, when she failed to continue the respondent's temporary restraining order. I believe the court should find me as the sole decision maker in order to avoid further conflict, which I have shown with the testimony by the respondent, as well as in an email and text evidence. That said, if the court has an alternative suggestion for mediating conflict, which the court will order explicitly, I am very open to it. I believe the court should find me as the primary custodian, as there is a historical precedence of me serving that role as the children's sole biological parent and primary decision-making that I have done. I am also adding that I'm very concerned about the respondent requesting full legal and physical custody because she has a romantic relationship with a citizen of Britain. I am concerned that after they get married, she might try, with her power, if she has legal and physical custody, to move to England with my children because her fiance owns property there. I'm also concerned about her request because her alimony payments end in November, with that being my last month of paying. And she has told me before that she needs that money to be able to handle her bills. By getting full custody, she will then be eligible for child support, which she has not been eligible for up until this point, nor has she requested. I believe she is not presenting a parenting plan that is in the long-term best interest and well-being of the boys, who after all of this need continued stability the very most. I rest my case.
That's your argument, Ms. Beekers?
Thank you, Your Honor. Your Honor, I really hope that someday Ms. Traverso will be able to reread her trial brief and see that it's all about her. It is all about her and her control and her desired control over these children. The mere fact that she is seeking sole decision-making authority over every aspect of these children's lives, including passports and name changes, shows that she is about control and that these children are pawns to her. In her trial brief, not once does she talk about bath time, bedtime, meals. Not once does she talk about taking the kids to the park or any kind of activity that she engages in with the children, because she doesn't. She makes the money in this relationship. Therefore, she believes that she should have control. And that is evidenced by her own testimony. I filled out all the paperwork for the doctors. I did all the research. I did this, I did that. That just shows that she did not involve the other parent, that she took this upon herself, acted unilaterally, got these things done, which gratefully, good, she got them done. That's awesome. But that doesn't mean that she's the primary caretaker of these children. The day-to-day activities, the feeding, the bathing, the dressing of wounds, the hugging, the kissing of boo-boos, the exploring and playing in parks and forests and rivers, the things that we have in the Pacific Northwest that children just thrive in outside. She doesn't do those things with the children. She either lets my client do them during her time, or she hires other people to do those things with her children. Never taken the children on outings alone. She's always had another adult present with her to assist her with the children because she can't handle it on her own. In her trial brief, not once does she even say that she loves the children. The trial brief is just all about her. It's focused on what she's done, what she can do, and what she wants to do, without any regard or consideration for the children or for my client, who is a legal parent. This is not an example to be set showing that she's willing to co-parent and share these children. My client explained through her testimony that the reason why mediation doesn't work is because my client is a victim of domestic violence at the hands of the petitioner. She is intimidated, she's scared, she testified that she gets gaslighted, and then she gets manipulated and overcome to the point that she just finally concedes. That's not a healthy relationship, and that's not mediation appropriate. Domestic violence has occurred in their relationship, and domestic violence has occurred in Ms. Traverso's most recent marriage, which lasted less than a year. That is documented. It is referred to. It has been testified about. A finding of domestic violence in this case is appropriate, and such a finding under the 191 factors would reduce her time. We're not asking to reduce her decision-making authority. We're asking for joint decisions. We are simply asking that the boys not be subject to week-on, week-off schedule with a parent who is so self-absorbed that she's not capable of giving the boys the empathy and loving attention that they need. She focuses on the money and what she does for them and the stability of her home, which nobody disputes. But the fact of the matter is, these boys need to be boys. They need to be allowed to be children. They're 4 and 7. And they need more attention than petitioner is willing or able to give them at this time. Therefore, we are requesting that our parenting plan, our proposed parenting plan, be adopted by the court. Submitted.
All right, thank you both for your presentations. Each side has presented the court with a number of witnesses and also with a fairly large volume of various documents, and so I'll need to take the time to read them and make sure I understand all of the factual basis for whatever I decide. We'll set the matter on to Friday, August 21st at 11 a.m. Friday, August 21st at 11 a.m. for my decision, if the parties are available at that time. Are you available, Mr. Traverso?
Your Honor, I'm checking. You said Friday, August 20th,
21st.
or 21st. At what time?
11 a.m.
I will make sure I am available at that time.
Ms. Petrie, are you available?
Yes, Your Honor.
All right, I'll reserve ruling until then. Thank you both.
Thank you.
Thank you, Your Honor.